So we're going to move now to our submission from Te Kahui Tika Tangata Human Rights Commission, and joining us online we've got Brittany, and we've also got Dale Takitimu. So kia ora kōrua, thank you for being with us. We've got you for 10 minutes this morning, so if you begin your presentation, we can start.
Kia ora tātou, mōrena. I am Dale Takitimu, the Rongomo Taketake at Te Kahui Tika Tangata, the New Zealand Human Rights Commission, which is New Zealand's national human rights institution. We as such have an A status for independence and standing to speak at the United Nations on human rights matters in Aotearoa, New Zealand. Our job is to monitor New Zealand human rights and Te Tiriti as part of our country's human rights framework. With me this morning is Brittany Peck, our Senior Legal Advisor. The Commission provided a substantial submission on this proposed piece of legislation of a very technical nature. I don't propose to read through that in its entirety today, but instead to make some salient points from that and then open up for questions. As an overview of the Commission's submission, we assert that Te Tiriti is a core agreement that affirms the place to belong and a place to stand for everyone in Aotearoa. It is the promise of two peoples to take best possible care of each other. This bill is not in that spirit. The rights and responsibilities agreed to in Te Tiriti are also human rights. This bill has been described by the Waitangi Tribunal as compromising potentially the worst comprehensive breach of Te Tiriti in modern times. These treaty breaches are also human rights breaches. The Commission is committed to building a future in Aotearoa where everyone feels they belong and we respect each other's mana, dignity and rights. The pathway to this future will be built on everyone in Aotearoa understanding, valuing and protecting Te Tiriti o Waitangi. This bill offers a very different and divisive pathway. The Waitangi Tribunal warned in no uncertain terms that this bill is likely to cause harm to race relations, social cohesion and to New Zealand's constitutional foundations, especially to Māori. Therefore, as you know from our written submission, the Commission opposes this bill and recommends heeding that warning from the Waitangi Tribunal, halting the bill and instead upholding a constructive, respectful and informed national conversation on Te Tiriti, underpinned by accurate information and public education with treaty partners at the table. We oppose the bill because it proposes to undermine and breach human rights. The bill would remove Māori rights that are affirmed in Te Tiriti and recognised internationally, including through the United Nations Declaration of the Rights of Indigenous Peoples. Although one of the reasons that this has been advanced is to protect human rights such as equality, the effect of the bill would be to take away rights of only one group of New Zealanders, that is Māori. In failing to recognise tino rangatiratanga, it undermines Māori human rights to self-determination. In failing to engage with treaty partners on legislation that so significantly impacts their rights, it breaches rights to participate in decision-making affecting them. These human rights standards are protected through, for example, the International Convention on the Elimination of Racial Discrimination, for which New Zealand is a party, and the United Nations Declaration of the Rights of Indigenous Peoples. The bill selectively focuses on some rights while actively overriding others, namely the rights of Indigenous peoples that are affirmed in and fundamental to Te Tiriti. This is an unhelpful and erroneous approach to human rights. It is an approach that ultimately undermines human rights rather than advances them. Furthermore, the bill's interpretation of treaty principles is vastly different from any previous interpretations and those developed by the courts and the Waitangi Tribunal over the past 50 years. These interpretations ignore the historical context and do not align with the intention, spirit or text of the treaty, nor do they reflect the original legally binding agreement and the premise on which Parliament itself is based. It ignores the unequivocal findings and directions of the Waitangi Tribunal and our international obligations. We note that Te Tiriti is the founding constitutional and human rights document of Aotearoa. The text of Te Tiriti aligns with core human rights principles subsequently enshrined in international human rights instruments, including the Universal Declaration of Human Rights, the International Bill of Rights, which is made up of the covenant, the two covenants, the International Covenant of Civil and Political Rights and the International Covenant of Social, Economic and Cultural Rights, as well as other United Nations instruments and commitments New Zealand has made. These principles include fundamental rights to self-determination, equality and non-discrimination, participation in decision-making, and cultural and property rights. The United Nations bodies recognise the status of Te Tiriti and its correlation with upholding human rights in Aotearoa. This is evident from the consistent and repeated urging by the United Nations to successive governments to recognise the fundamental right of Māori to self-determination. Furthermore, we note that New Zealand, in a horizon poll undertaken by the Commission in late December 2024, shows that a majority of New Zealanders, that 71% of those surveyed, believe it is important that Te Tiriti is protected within our laws, not redefined, I note, but protected in our laws. And a majority of people in Aotearoa want to see a respectful discussion of Te Tiriti and race relations rather than political rhetoric. And also, when asked about what is important for the future, most felt that harmonious relations through the honouring of Te Tiriti is important. That is 72% of New Zealanders responding to that survey. We note that the United Nations has also taken the special measure through the expert mechanism on the rights of Indigenous people of writing directly to our Prime Minister to express their concern at the progression of this bill, and quoting from that letter dated 13th November 2004, the quote from that letter is, "We wish to express our deep concern regarding the Treaty Principles Bill introduced to Parliament on 7 November. This bill seeks to set principles of the Treaty of Waitangi in legislation and requires those principles to be applied when interpreting legislation. The Waitangi Tribunal found that if this bill were to be enacted, it would be the worst, most comprehensive breach of the treaty in modern times. In the view of the expert mechanism, this could raise serious issues of discrimination, lack of consultation, and potential breaches of fundamental rights articulated in the United Nations Declaration of the Rights of Indigenous Peoples." The Vice Chair of the expert mechanism then goes on to the New Zealand government, as does the New Zealand Human Rights Commission, our advice and our guidance in ensuring that New Zealand stays consistent with its obligations, both under the original agreement of Te Tiriti o Waitangi and under its domestic and international obligations. Kia ora tātou.